Me say mama winia me ko Togo for 4 years.
Adedia. Why?
Mama government. So oba bede.
Oba represent for me mo akwa about 1 hour with Munufie so me gidi say obi a ho eye. Na ene Ghana in 7 dozen. Allah talai. Hey. Supreme Court of Ghana ene tenase no Supreme Court say collation was a recollation was there ECN na no. Almost say dodo na no wagadre. And the Supreme Court order say most 4 out of the 7 coalitions from here no omonjentum. And the baby at Supreme Court of Ghana at the end ekodu no. Now the host say omo kana boss my sarity wa dream wa say there be. Manda e dey assembly bebre. And there was for ene ye ba be discuss Supreme Court. Nsema tenase ene e de bae no eno bi e na ye ba hwe. Nti mama ye chase. About what they are saying about Deputy Finance Minister or Kenny Kwame say mommy about 2 years something Japan ni I say mommy to buy detail you or to buy detail now crow and part of my minute of benefit omo NPP ayeka yey I go no I'm koya mawa bisafo wow to who say baby a mami di kwesi die asa otuti ami na kukuro ene dem ya laji we na me komeka na bisafo say me komeka you say me ko fere nyame ya who say Ghana. But Ghana is very funny. Supreme Court, so what by your power, it is something different. So what by any power, it is something different. Very probably better answer no. Because most of the verdicts in the free Supreme Court, I say the GDO courtroom no. Sometimes odwin ho a enye sometimes sometimes enye. Now, with information, I say me say you hear historical facts about Greater Accra region. No, me they all call historical facts from President J.J. Rawlings and Benso, ABC John Dramani Mama Penso. Now you hear how you hear kwanya Greater Accra Faswa Etwaba Epacho. These are data facts. Alhaji Dr. Mahmoud Bawumia say. So we share politician be na say ubisan so more data na when Techiman farmer was a politician and engineer. Enti me pacho mama here Facebook no dey any YouTube. Pacho me who this particular facts. Me pacho mama here sa facts we never had it.
When
Until you're saying about your mom here, YouTube, I guess say you got all the facts, all the data. If you Greater Accra region, about ultimately say NDC, a born home modern, Greater Accra region, Greater Accra for maybe an Edamasi. But you're well, now here on TikTok and so, Medawasi, and then that would can hear me, any William Monufi, Amam Konami Pacho, channel a 1 hour with Monufi, streaming 1 hour of our time. That is why the name 1 hour with Monufi. Minas Ali, you will hear me from Italy, Rome, Edasi. Ernest so is bad on the game. William Cap and Ernest. Of course, you people have been part of the game always. Until wow, hear me, nene da hear me Edasi. Now, but in the Supreme Court, the Supreme Court per say 4 out of the 7 seats na easy equal equality, you know. Omamfa kwan paso ene koye. Enti asen declare say those 4 seats, you know. Yes, I'm fast. I'm not back to the Supreme Court, back to the High Court because High Court, you know, I'm NDC hearing a case, you know. Now, as I'm by, and it seems many people are confused to say, saying that as I'm nankasa echere. nipa dodo na no I confused say asem na se bi mu ntia say bi mu adwen ne say oh what the Supreme Court actually means ne say NDC are winning those seats ne binum so say that NDC winning yenti ye be bonchire mu ankasa na afede ma kire wase how asem na ankasa etie oh say asem no call high court no high court anti NDC asem kra high court actually efre NDC lawyers said they were friends of the court, meaning say they were not part of the game. But Supreme Court said there be, yes, I go back to the court no. Na court no Emma NDC here na enye NDC nye part of the game. E biem no so no sa judge na what na high court ase no. Supreme Court said there be judge dey give dia enye ye. Isan say in a way no, judgment na o man ase na wa adwen money kakra bi o wa adwen munti. Ye ma different judge ene metena asem no so. Na nea echiri nipa dodo na adwene se ebi bisa se enti so NDC awene anase den me ma adwene chiri about the law no court ne se yensan call back to the high court na yenkodi asem ye wi a ene be hu asem no pomase bre enti as we speak ne de Supreme Court person che say those 4 seats no ye declare why declare ma no we declare ya wene enti se yes enti asa yenko na high court no yenko bobo mu but enye final no me pa che yenti ha yie. People are confused about this. A bit about say high court besia tenasono. Obeka said that 4 seats in Abano bill ha collation it was not properly done. Timusan ku collate for. If I told me hi, don't get confused because I have gotten a lot of messages. Nipa Dodona seems to be confused about the whole show. Intimema yako ni yakotie Supreme Court abra ye deliver judgment in some kaya, but this is the explanation I'm the Supreme Court say 7 seats na ye equality wa Accra no. Or say 3 they are sure say collation no ya nyanwie. Enti ajetum say yisi collation akwa wa Accra no in a way no omajatum. Enti those 3 seats na ekoma NPP no Supreme Court acknowledges ampa collation was not finished and I was not done. This say omase enfofra omajatum. Now mum 4 na akane de Yensan go back to the High Court. Now High Court ma end this opportunity to argue their case. And the NPP, any easy in one side say collation was not properly done because omo officials did those declarations under duress as a share omo and omo ye. And at the position of NDC so said there be answer now be argue say you were under duress now the declaration and so prove it with some facts and yes old quality we now declare we are the one no kwa koji na say obi share na maye enti that particular moment on high court on anti NDC asem kora e pa chew enti near Supreme Court e kan and then say high court on emma NDC opportunity to argue their case enti e betimi aba say NDC ko argue the case in a high court on enti men ka say obeti ana so enti because me pa chew the position of the law is what I'm explaining to you. Enti mesro my NDC for mose kesese 416 na abaye ho in a way from one angle no you declare all those 416 in the NDC dear enti one might argue say Supreme Court see and come back enti see enti man ka sem na enti ne puma sibra NDC are just 416 no. But in principle and in law no NDC engage those 4 seats as we speak until say high court no be make that declaration say be oh you quality ni ye and I say it was not under duress and you quality ni ye but let's get our facts very carefully. Enti me pese me the whole court Supreme Court na fe de yenko ti abra Supreme Court man the judgment the bar I will take you through whatever transpired at the Supreme Court today. Until man wo YouTube today, you get opportunity to see the video footage, but on TikTok there you only hear the sound or the voice coming out of the justice of the Supreme Court. Until me pacho mama yenti
were declared in all the above constituencies, and the election process advanced to collation of results at the constituency level in order for the winner of the parliamentary election to be determined and declared. In the case of 4 of these constituencies, the applicants contend that the collation exercise had completed and then the parliamentary electoral results were declared in their favor. In the processes before us, the first to seventh interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the second to seventh interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16 December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the two applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. The Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application for mandamus. However, Mr. Godwin Edwigi Tema of counsel for the applicants herein stood up in court and informed the High Court judge that his clients were interested in the mandamus application and that they had even filed a motion to be allowed to join the mandamus case. The judge decided to proceed with the determination of the mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the second to seventh interested party raised a preliminary objection and pointed out that the rules require that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the courts. And in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the applicants first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit to be affected by the proceedings for mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contentions that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the mandamus application. Additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for mandamus, being Order 55 of the High Court Civil Procedure Rule CI 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Public versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana Law Report. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the mandamus application, but by opting to hear the mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chachikata, 2005-2006 Supreme Court of Ghana Law Report. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edoji Temaklo stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts, and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally, and Order 55 judicial review. In the case of Awuni versus West Africa Exams Council, 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edridge Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court, as recorded by the judge himself, and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Hafwano North are not affected by this order, by this our order, and in effect, those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now, those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My Lords, we are extremely grateful, extremely grateful.
We are grateful to the court. My Lord, you are grateful.
All right, episode 4 made that was say when you're now here 1 hour with Munufi. Now, surprisingly, no, Mensaka, the parliamentary candidate of Techiman South of NDC, you can say the on the MP elect for Techiman South, Honorable Christopher Basunte, by me show you so. Many I mean, join you,
Many are Johnson Apomwe.
Yamadam Hoyapa, Techiman Bokode.
Techiman Boko.
For the avoidance of doubt, we say Obo Udin and send a bayer will be or way be say and no correct say Honorable Christopher Basunte Bayere, Techiman South NDC parliamentary candidate for 2024, and I mean Udin Komwe.
Oh, okay, me that's a friend me Christopher Bayere Basunte.
Okay.
Parliamentary candidate elect Techiman South.
Okay.
Speak now.
All right.
On the ticket of the ANC.
All right. Medasi. Na I say about we didn't care the Azaya Jeffrey Semo.
I said, Minia, I said, me, yeah, me didn't say, Yametias and Yami.
No credit.
If he said 2020, no, yes, see, and yeah.
No credit.
2024, almost I saw more repeating the same thing. And yeah, what me young grantee any major interview.
No credit. So they are
not me bumper.
so ultimate dodge me ye.
What on your mature? The same thing, Nanka. On person more repeated.
Yeah.
Say, we pay quite this. Now, was I did by force? If you say, time I did almost time a major a collation car 2 ballot boxes are moment being in Kaya, most of trying instructions from above. From above, baby.
Above me.
Oh, yeah, but above the just most are planning the same thing.
Yes.
Oh, but I mean, so far so good. Supreme Court, natural justice is a fundamental right of everybody.
No credit.
And he say, "Uti one side, now one the other side." I say, "Only independent."
No
Supreme Court has
no credit. Yeah, so yeah, that was the same. You what me ajemre na oni esia atwen komonti. Papa ni di ba ko se de fe aje udin. Ana no de wo de ate.
It's Dini Dawson.
Dini Dawson.
Ajudi Jatabedi. Dodo.
Papa, open man baby, and Pomana sem den. Enti. Mate ye bompa say High Court be make final judgment na fide ya pagya wasi akonkon nti asana wodi ne de unni asana mane nkokwa ubedi ato aso. All right. Bye bye. All right. The Honorable Christopher Basonte Bayere ena menina twetwe enkomo live no na wamaye hu say in fact ne aje wo hwe seria papa isere de otimu say in fact enije abafie. That is how politics ni no Christopher Basonte Bayere menua kan me yonko pa no nti onye hoho emame. I think say me boni pono mre bia ojeme so. Inti adia Supreme Court and I think I'm very happy with that. Inti a bompa say ne be ya High Court no betimi assume edi amaye. Na abusa for senior Supreme Court no e kan and say me from French and some kwanimu. O say asem no yensan ma ne nko High Court obiem. Na High Court no emma NDC opportunity and presenting the case. Inti wama NDC 2 days NDC and from presenting the case within the High Court. Na ebiem nso no o say try judge na otena so no man ntena so biem enyini sinchen papa no omonche ne hu ne ye tiene so omayine sinchen na latest by Friday I was say High Court ntimi tena so na sa 4 constituencies no bibia ese o ka fa ho bia no ese ye ka e de fa ho ntima bone to fa e de ma na affected constituencies no eye Okaikwe Central, Tema Central, Techiman South and Ablekuma North. About these 4 constituencies, and court, Supreme Court, and they say High Court and San Court to be about so what question BBC wait me ascend me interview question na my church if something is very a chill wide being kakra and the final say Supreme Court and say be declare all those and as a stance in the nipa 4 no on these constituencies na declare no is still stance no Supreme Court and say eba parliament in Munsem there a High Court in the determined High Court na NDC opportunity to present its case a one NDC be kwa say ye declare among candidates that so the candidates have actually won ti wa won ti ase no for High Court after they have sworn them in as MPs. That is the orders of the Supreme Court. That is how we are going to do things. Wow, what question be at Mepacho with me, Ediaba? All right, and yes, it's a bill avocato go.
Boka. The children rap where she come cook just for information.
Atija, enti buba by na mehwe se Oh, me I mean yamata James Akos at Hona Papa any my style. Hey, asemo. You go ko dia sa easy akoye kana sisi kwan aja konwa da ma wadi asa afi don't want Supreme Court abasi da bia sene wadi ni kwa. Agora de be de say nsuo no. Ghana I was say jai court and say court and ma fair judgment. You could see the court and the judgment, a lot of judgment baba. Na judgment and I had ya Techiman for no any home. It is a no case ya. Supreme Court a kaya. Utimu say the judges or the justices and they were freely deciding their case. Enya this will be now trauma say I say we naka. That is how we want justices to go in our society. No, Millicent, about Obwasi Denide, Omanka Bibia Amfa home. See, baby, how I know Zubeko. But the only good thing is that you per se judge status no. Mama Ghana for any confidence, our judgment ebanomo. That is the only thing I Ghana in Ibia. Men can't say be na kwa men this in continue. But you could see say the judges no, they were freely arguing their cases with the councils. Omuno mudin komo free. Enya this obia epoma. Obia empomo obia ntata obia nya bibia we now when na no dem kan dia you could see say it's like as a group in an yedi. Intimidation, they didn't say anything about that, but let's see how it goes. That is something we're going to discuss as we move on. Until Pacho said, "Any that would can pay any William Monofia." This is 1 hour with Monofia. That is how we've been live streaming always. That is how we do it. I was a high end in the atoms. I walk on see now, mommy. David. You can't answer some send you a melanitiano. Now, check him, send him some no corner. Now, check him. That is how I think it's a serious society behind. We need to build it. One thing about social media, you want to say, oh, more or media terminal. I'm not saying I find fault with them because we are. Sabi, nipa bi who went in a tema, answer. Into some are like that. And you want yen so yeso e chamfina yeso ye kane senia asem no etie na ya kire adwen oso bibisa inti ye behwe bibisa na afede yaje adwen kire possible outcome: 1, rerun of all the constituencies; 2, maintaining the initial declaration; and then 3, maintaining the recollation results. Inti mene lawyer chum ebedin komo afa this particular issue na afide yahwe sene lawyer memo ojo nyumre nyame adom ho ye pa ma hu se why busy kakra se wo drive na we dey ye monitor Supreme Court ekwa asetena ene no almost say recollation na easy ekoye no but the rule of natural justice no omama NDC hearing in the High Court case NDC court no asen say High Court no ma NDC kwan e wa High Court na omonsan ko agi omo case. Lawyer Pacho Bonitofa, what is the actual meaning of this particular declaration from the Supreme Court?
The court person was trying to say consent. And Remono, I couldn't yes say what can I say as a judge and answer where a court are fashion.
Okay.
So I'm around one password. This is simply a bit add the issue from the beginning they are wrong. Until we hearing, you have to give the other side the opportunity.
Okay.
Now you almost work out the finance and what's here. And on top of it all, also so man of good hearing or fair procedures.
Okay.
So James and them are in Afra. This is simply a bit taken out of it. They are wrong.
Okay.
That is the conclusion of the Supreme Court.
All right. Enti minia Rasness Simimbisa will say, what if you come back to the court? Na court next time could declare say, I think say my messy lawyer kakra. If he's back on the show, maybe on this particular question, Rasness abisa. But Rasness, what it means, and say, of course, my main free jazz photos. Jazz, okay, me free Techiman. Your question is why back to High Court? And you say, as I'm call High Court, no. High Court and a share easy say easy inquire recollation for but whilst High Court Emma's declaration no High Court on Amma NDC fair hearing. So my NDC and argue the case kura. And she say no Supreme Court say yansan go back to the High Court. Na High Court no my NDC opportunity and argue the case. Just about you say claim about what you say. And rasness and so question is say. Let me bring the questions back on the show now. After the yes, I will be back. Say, Abia, me ankasa na mabomi Tema me chro. Ras mess. If I get your name correct. What if the High ruled in favor of the NPP candidates? What would the NDC do? Right. And it is a High Court ruling in favor of NPP's candidates. What it means is that they are the actually elected MP, so they will get the opportunity to be sworn into Parliament on the 7th of January. But the NDC and NDC will have to go back to the High Court again. Now you argue, say, elected. So that is also another opportunity. But what I heard from lawyer Eduji Tamakulu and lawyer Wabo lawyer Eduji Tamakulu say, techniques are NDC they go physical court and they NDC they betuja. But per the layman's view of the law, no. Say, yemfa is nyankopon pangudie. Yemfa is go back to High Court. Na High Court so NPP for away ni abana. NDC will have to go back to the High Court again. In some way, a bit of style be but chama UNESCO say style be abi. Inti we ebe born style be abi na yemwe hawa ebeko. Inti just photos. You're watching me live from Techiman. Techiman South. Maybe if Techiman South. Yeah. Techiman South in Intino. Wow, I don't think so I'm just biased. Christopher Basun Teba by 2019, yeko NDC parliamentary primaries no na meka hobby. And I Chris Wene and I know Chris. Techiman South, so I know everything about Techiman South, you know. But then NDC nipa me nkase me infinite debi. Uti me show there you have to know say NDC as seven American because me NDC ni. Because I mean opportunity and can name a member of parliament for Techiman South, you know, me NDC. So I argue my case. But I just me fail so that I have to be careful because my reputation and integrity is always at stake. Inti me can't say no so me can't send ya etie. Me nitro. Me until I can say 1 hour with Munufi me near them. So that is how I go things. Inti just say what I say that is something I think say we need to be straightforward. Inti no me pacho ma say NDC for ni because NDC are winning. In a way, no. What the Supreme Court has said, no. I mean, it's okay. Techiman South, Christopher Basun Teba is the MP elect, but say High Court no for stamp in CE because as seminal right after election it can't call High Court. So that is it needs to be clear with that. That is how it needs to be. You know, they say by Friday by in a High Court and the stamp BC so am you position ankasa. What I want to send there, which means you need to go back again and file a different application at the High Court because per Ghana's constitution, High Court in the determine either say at by you and I say by you, we are a member of parliament and now you're a member of parliament. So that is how it needs to go. Until just photos, maybe a program I'm for I say my Yaraka Carantino and he's just the bend. Mo Boka. Yeah, boy, by our High Court, Supreme Court say Kim, here's a Martin James and Cosa. Say, Papa Bokago. Martin, and Yahi, Mansu. Minister for Local Government, Mansu, Mini and Mansu. Oh, dear, and Yahi, where the 4 years, I'm a crisis to maybe 4 years. If it will be an elder mess of Mr. until the young Quenis are and Yahi, Man Casacora. Wabokadi about the Man Casa Tranchain. Na Mama Oren Hokese. Mama Oren Hokese. Why, Mr. Unti wow abana anko ya maobiano pena amare ho nti anko ya mawa ema ore enho enti me hwese metimi assign the lawyer aba back on the show na mabisa no baby na already kan wa wo hwe me ana wa utimi bia na wo beti aseye so I will try some nyan lawyer there then I think say anyway lawyer line and go through until let me just take it like that na fi there yen twice 1 hour with Monofie me pacha unti wote Christopher Basun Teba the MP elect for Techiman South on the ticket of NDC enka na afidie no William Kabin Sawam Adwajiri wasn't mentioned because time no endu ho he do why so the baba MP dey enye adwuma kete o chale campaign rounds pa obekọ as na obe lose or lose no we easy tin am for etia no am for etia say because we campaign easy. We might call campaign 3 times now. Charlie, premise you can bra me bre no. Hey, I'm say, hey, now this say we premise we can go face we main opponent say na bre. Hey. Hey, ozo pempi dia. Nia. Bra bre no. Wow, be koroza ma be wuze hyehye. Wani kan na kwabana ni tutiawo. Hey, asembe ni. Ti obisi andi ti we ni obeko Togo me pacho ti se o he.
Mak me see mo platform so eso. Me see mama winia me ko Togo for 4 years.
Adentia. Why?
Mama government. So oba bede.
Say mama ba bede ne Togo ho beka ho. Togo beka ho. In terms of 4 years na wa ba no be hwa de kura mama ye nyeme na meka kire wo. Ti la mo sampa ba che wo hye Togo abanti a kan so nsia French ka bi go Togo ye nka brofo e de nka twi. And as a champion say they lost it or say another pray then as a for no we say o mani mai sebe e kan so mani mai jobi. Ku fi am kwa bi ne bi aboko de. Good evening to you also. Me da say we ulu so aneya. And as they say they lost it, you could see from their faces another prayer James say ko say ku ya free enko o mani mai titi ne kan say mani mai jobi. Hey, Atija. Millicent. Morrison Power. I think so on them Togo. So say mama we near. Obeko Togo for 4 years. Mama so we ne. See, ushi ana Ghana no business lawyer na we ne ha. About all. Deputy Finance Minister ko to ba no papa yes or hwe ne obi ojan chen yeto. Se kai mami o tutia me. Ona wo twe kon wo hwe say hey ti mami u je santi me pa out to NPP so that agora ne ko
Boka.
hey Samira ba mi a
Anya fulano fo. Mo kware ne ti. Wa sia o te petse. O ma mi
hey oh sisi fiane bi oh sisi fiane first year na mama oh sisi fiane bi a teacher
Hwe Bible mu a obi a wagimi bia Yankopon akasa twe ne safiri ne ho.
yo cheddar mon homode about to kwa cheddar sa unimu ye to ba wi na cheddar be press conference o ba buza for me to ma me ho me ye to ma me ho awa wi now how we enti na kwa me be di akon kwa ye campaign akwa fa avran mo se ye be di wachi papa iso unfuturo nko a na oto sa mo ina ba to ro monte ase cheddar si yisi so on twere application letter major accreditation I don't know onim sana over 40,000 application letter by natural aka sa accreditation ye chiche na kwan ho obi asore ko ya o se major accreditation dey ma no say nen ko obi ya be accreditation papa ni modwuma no on tiase ya twere application say accreditation cheddar next time open your eyes as an alcohol ba one good thing about cheddar and say wa moka osan German for sika na dey campaign no ono ankasa ne dey yera cheddar nyi wansi di kura obi a platform so wa person obo na campaign be first ka bra na ogigi German for sika no dey go around ade o ya na say car one dey go around the car no the only car cheddar boy mileage na car ko na nya sa cheddar moka bia ontua ka pere kura na kwa na ni at rough o se mo ka se mo jimi mo ka se beto ba tia me san fa mitika nye but dem fa mitika mra me beto petrol akoda hotel na mum mileage ni de me ya me de me car be go round sa ka ni de ma jafa Facebook gi sika no sika free na ni si I was say hey mami nti oto abayeti ame oh mami sa in pa boni ni sa oto abayeti ame ona bade that's all you know or we know en ha no ona bu gina sentiment pa na eto abayeti ano asemo anyway we stand for 1 hour with Munufie and me the basi we have a question bibisa e pa in the comment section obetime e dey about me din any William Munufie amankona na channel e 1 hour with Munufie pa on YouTube 1 hour with Munufie, on TikTok 1 hour with Munufie pa obetime share your content na fe dey eno nyina adi kasobom abom na ene me no kasa the Supreme Court say recollation, 4 out of the 7 constituencies been more ha. Ejituma enye. Ebiem no High Court trial judge no yesi adwumadi a odi High Court no wani ni yenti yesi aba hon kwan ye hia os asem no kra no. Obeba hon. Enti my NDC kwan ma within 2 days NDC in filing the case na me argue say ejituma panifo no inform members of parliament elect. Nti wa udi asa bia metise Techiman Methodist Park na NPP fu edi asa ene metia
wo de wa no fe fire hu wo to ye mrade isa ye ma otumia o meyi mu beye de ya brabo beye fefe
matese NPP fu bi accuse say president na Adodankwa Akufo-Addo ene mo mulusu aba Mamudu Bawumia na nkasa ne mo onu ankasa ne lusu aba enya na ado ko ye vice president for 8 years nti ohun se na ado mo ne homoden no na ho kwan se odwane anko e no to no nam na o ye kampi ko ohun asema o ka hobi na o Mamudu Bawumia wo ye de jomama agina fa o Mamudu Bawumia se wo ko we ne jomama adede e bone na nka visa Ghana fa ye madamfo I wish for my fancy with Hana Mamudu Bawumia de on the a pension no young person a pension. So I'm so saying 38%. Oh my be why year every politics room. E di me do baby I say 1 hour with Munufie say oh question bi am pa chaw ubetimi aba.
Dia ya wo mu kwa ne say ubeso wo TV ana ubeso wo WhatsApp no ko ubete krrrr abade na me yawu. Don't mahama abade buani pa na wa buani pa. Doma, I need us to any everything we need for any that's what. What is the TV I said? I just a Buakuma, Titia Kuma, just a me, TV, BM, our Miria Siame buyer. I am a missing part from your bedroom, baby. Boka, and your full Boka.